Hearing in the appeal, Roberts against Gill and Company Solicitors and others.
Yes, Mr. Graham.
May it please your lordships, in this matter I appear with Mr. Guy Adams, the appellant. The respondent is represented by Mr. Thomas Dumont. My lords, in this case, the Court of Appeal declined to grant the claimant permission to amend his particulars of claim, seeking to assert a derivative action against the defendants on behalf of the estate of Mrs. Roberts. They did so on the basis that the making of such an amendment would also oblige the claimant to join the administrator of Mrs. Roberts' estate as a party. Such a joinder, it was said, was a new claim within Section 35, subsection 2 of the Limitation Act 1980 and engaged that section. As it was common ground that the limitation period in respect of the alleged negligent acts had expired, the claimant could in consequence only succeed if he could show that the application fell within either Section 35, subsection 5, paragraph B of the Limitation Act 1980, or Civil Procedure Rules, Rule 19, Subrule 5.3, and they held that it did not. My lords, the conclusion that arose from all of this, if that reasoning is correct, is that the amendment which the appellant wishes to make is precluded from being asserted, and the proper case, we would say in this case, argued by a requirement of joinder which the claimant has never sought, which the defendants did not raise or require, which there is no evidence that the administrator would object to if he were to be made party, and which the defendants now assert should take place for their own practical benefit.
I rather got the impression from your case, but please do correct me immediately if I'm wrong, that you were accepting that procedurally it was a necessary step. I mean, there's obviously a considerable argument about whether there's any change in substance, but do you accept that as a matter of procedure the joinder is necessary?
I put it this way, I accept that it was an appropriate case for the Court of Appeal to decide that in the circumstances the administrator should be joined. I accept that. In my submission, the judgment below, and indeed the respondent's case, errs in failing properly to distinguish the consequences of two quite different situations. First, where the joinder of a party is necessary to constitute a valid cause of action, which, if necessary, I'll refer to as legal obligation or black letter law joinder. And secondly, where joinder is directed as a matter of procedure for the better, fairer, or more efficient resolution of the case. Again, if I need to use a vocabulary, I'll call that procedural joinder. It's the appellant's case that it's only where joinder is necessary in the legal obligation sense that questions of limitation arise.
So can your first proposition was necessary to, just as I get it exactly right?
It's only where joinder is necessary in the sense of legal obligation that it is necessary to join a party to constitute a valid cause of action. That Section 35 is engaged. The distinction is one, we say, that's easy to blur if one is talking about consequences such as having to, must, or even simply necessary to join a particular party. It may be necessary as a matter of fact. It may be in all the circumstances necessary. But if it is still a procedural requirement, that is different, we say, from a requirement of legal obligation. We submit that the Court of Appeal, in fact, if their judgment is closely scrutinised, appears to have regarded joinder in this case as a matter of procedure and not as a matter of legal obligation. But we also say that the Court of Appeal did not follow their analysis through from that. My Lords, with that brief introduction, I'll pass on to the case, which starts with a consideration of the nature of a derivative claim insofar as it applies to the amendment in this case.
Yes.
We accept the oft-stated principle referred to for convenience in the cited case Prudential Assurance Company and Newman Industries, that the general rule is that the person in whom any right of action is vested at law is ordinarily the proper person to pursue any claim for relief. And perhaps if one was being particularly precise, one would say legal relief, in respect of a cause of action against another party. Derivative proceedings are an exception to that rule and therefore shadowed by the rule being defined as a general one only. We submit that there are certain common characteristics that apply to derivative proceedings, and they are these.
Common to what? Common to all derivative actions, whether they be company or
Yes,
trusts or whatever.
at the risk of being grandiose, yes, that's right. Whether indeed we would suggest they are company derivative actions, whether they're derivative actions brought by beneficiaries in respect of rights vested in a trust or an estate, or indeed we would suggest whether they are examples of equity enforcing lawful legal rights by way of, for example, equitable assignment in respect of contractual interests. Those common aspects are these: that first, the right of action is vested in another person at law. Secondly, that there are other persons, including the claimant, interested in the right of action by way of shareholding, by way of trust, by way of fiduciary or other equitable obligation. And thirdly, that the relationship between the legal owner and the other persons is such that equity may intervene to protect the cause of action in favour of those other persons. The position in equity is quite different to that at law. At law, going back to prudential assurance, only the person in whom the right of action is vested can bring and pursue the action. But in equity, we would suggest, anyone with sufficient standing can seek to enforce a cause of action in equity, and the question of whether they're entitled to initiate such proceedings is a question of standing.
So can you help me to grasp this? Because I'd like to understand how equity comes into it. I think I can understand it in the case of assignment, where the assignment assignation has not been completed. Is that right? Where it's understood that the assignation or assignment will be made. But equity, you say, permeates the entire structure of derivative claims, does it?
It does. If one looks at the categories of action in respect of which derivative claims have been brought, historically, the oldest are those relating to the administration of estates and trusts. In those circumstances, equity will allow a beneficiary in certain circumstances, and one of the issues before their lordships in the Court of Appeals what those circumstances were, but they will allow them to bring a claim which is otherwise vested in the trustee or the administrator of the estate. The relationship that arises under the trust or in the administration of the estate is an equitable relationship recognised by equity. And in that case, equity would allow a derivative action to be brought, and that's probably the oldest form of derivative action that has been found.
So if you're asking yourself what is the cause of action, where do you go? You go to the other party, as it were. The equity is in the person who's seeking to bring the claim, but the cause of action belongs to the company or the trust.
Well, that is so. The cause of action is vested in the lawful owner,
yeah, right.
The owner at law. It's the equitable owner who has an entitlement, amongst others. There may be other people who are entitled to bring it, but he has a right to bring his claim. Rules, of course, that's necessary in order to provide a threshold test. It's not the case that anyone can walk into a court and, with any scrap of validity, issue a claim and say, I want that determined. There must be something that entitles him to invoke the court's jurisdiction to act. Now, ordinarily, he will be the other lawful claimant, or the lawful claimant, and that won't cause a problem in itself. But alternatively, he may be somebody who has an equitable interest in asserting the right, and if he has sufficient standing to do that, then he may bring such a claim. I'll come on in a moment in the case to what I've termed the internal management procedures to when the court decides such a claim should continue and whether it may not. But authority for the proposition that anyone with sufficient interest has standing to bring such a claim is to be found in the judgment of Lord Millett in Waddington against Chan Chun Hu Thomas and another, the Court of Appeal at Hong Kong, and it may be appropriate to refer to that at this stage. Yes. It's volume 5 of the authorities bundle, and it's authority number 61.
Which number did you say it was?
Number 61.
61. Yes.
Lords, the real issue in the case concerned the availability or otherwise in Hong Kong of what was called a multiple derivative action, where a shareholder in an ultimate company sought to bring a derivative action not in respect of the company in which he held shares, but in respect of a company that was wholly owned by the company in respect of which he bought shares. But in the course of his judgment, Lord Millett had cause to comment on the issues of standing or entitlement to bring an action of such a sort. My Lord, the various objections to the bringing of a multiple derivative action were considered by his lordship, and his lordship simply said that a multiple derivative action was in truth two derivative actions, in effect staggered. And at paragraph 70, his lordship said this. The first objection, that is that at common law such a multiple derivative action shouldn't be allowed, is seriously weakened by the fact that other Commonwealth countries have all legislated to introduce multiple derivative actions without finding it necessary to make any significant changes to company law to accommodate them. Both the first and second objections depend on the same analysis of the multiple derivative action as two or more derivative actions which have been consolidated into one, as its name implies. But as I indicated at the outset, the description, though convenient, is deceptive. The action is a single action on behalf of the company in which the cause of action is vested. The only question is whether the action, which may be brought by a member of the company, may be brought by a member of its parent or ultimate holding company. This is simply a question of locus standi. So his lordship there recognises that the right of action at law is vested in the person to whom, the company to whom the wrong is done, but that if a remote shareholder, that is a shareholder of its holding company, seeks to bring an action, the question is simply whether he has locus standi or not, rather than any more technical restriction. His lordship then...
Just to look at paragraph 71, just to get a flavour of the kind of complications that can arise. Just glancing at that, I can see that somebody may be not the legal owner of the shares, but the equitable, and can you really stretch it that far? That's the kind of problem, is it, one may...
That is. As I understand it, the general rule is that you can't. There are good reasons why a shareholder in equity is not, as a matter of principle, allowed to bring a claim. You have to be a registered shareholder, in effect entitled to vote, in order to complain about the misconduct of the company. But your lordship is right that this is an area which has thrown up nice considerations of policy and distinction when working out what is appropriate locus standi. His lordship then dismissed various objections to the multiple derivative action analysis, and then continued at paragraph 74. As I have said, the question is simply a question of the plaintiff's standing to sue. This would have been obvious when the procedure was for the proposed plaintiff to apply to the court for leave to use the company's name. On a question of standing, the court must ask itself whether the plaintiff has a legitimate interest in the relief claimed, sufficient to justify him in bringing proceedings to obtain it. The answer in the case of a person wishing to bring a multiple derivative action is plainly yes. Any depletion of a subsidiary's assets causes indirect loss to its parent company and its shareholders. In either case, the loss is merely reflective loss, mirroring the loss directly sustained by the subsidiary, and as such it is not recoverable by the parent company or its shareholders for the reasons stated in Johnson against Gore Wood & Company 2002 to appeal cases 1, but this is a matter of legal policy. It's not because the law does not recognise the loss as a real loss. It's because if creditors are not to be prejudiced, the loss must be recouped by the subsidiary and not recovered by its shareholders.
Johnson and Gore Wood is not a case of a derivative action, is it? It's where the shareholder says that the value of my shares has been depleted as a result of the defendant's action, and because that is the same as the damage to the company, for policy reasons, the shareholder isn't entitled to recover that.
Well, that's right. In fact, Johnson and Gore Wood was, in part, a preliminary issue as to the existence of a separate duty owed to the shareholder. And it was held that such a separate duty did exist. But in effect, it was the same duty in content as the duty that was owed to the company. And, my lords, as we shall see, that's, again, a similarity with the extant personal action in this case. Their lordships in Johnson and Gore Wood held that purely reflective loss was not recoverable as a matter of policy. And their lordships again relied on the basic rules set out in Prudential and Newman, that there is in effect a hierarchy of entitlement to sue. And in that case, the hierarchy as a matter of policy meant that the company was higher up, and that therefore there should not be double recovery when the company had already settled its claim in that case.
So does the principle of reflective loss apply in this class of case?
My Lord, it certainly would do, because if one looks at the claim as pleaded before the amendment, that was a claim which asserted a duty owed by the solicitors to the claimant. The duty that was owed by the solicitors to the claimant was in content exactly the same duty as the duty that was owed to the estate. It was a duty to take all reasonable care in advising the estate. Indeed, it could only be the same duty because it arose out of the same retainer, and that was, the retainer was between the solicitors and the then administrator. The breach is the same in each case. It's alleged the same thing went wrong. The solicitors did the same thing. The only loss that is claimed in the pleaded claim is the loss arising from that breach to the estate. So the claimant, as a residuary beneficiary of the estate, was in effect asserting that the value of the estate had gone down and therefore he had lost. So his claim was, if one looked at it in Johnson...
So is the measure of damages the same?
No, it wouldn't be. Because, of course, just as a shareholder can only claim if he claims a direct duty for the diminution in value of his own shares, if he has a personal claim. If he seeks to bring a derivative claim on behalf of the company, he is stepping into the company's shoes and can claim the entirety of the loss that the company has made, but it would be held for the company, or in this case, for the estate. So the quantum differs, but in respect of each of them, my Lord, this is something, a point on which the respondents and we differ sharply. We say not only is it in respect of a similar cause of action, it's in fact the same cause of action. It's the cause of action is what's vested in the estate. And this is reflective loss that we were claiming in respect of. But, Lord, if I might develop that when I come to look more specifically at matters of limitation, I'm more than happy to do that.
So you say it's the same cause of action?
Yes. That's our contention. That's right.
How can you ignore the fact that when the assets are recovered by the estate has to divide whatever the residue amounts to amongst the three beneficiaries under Clause 8?
My Lord, we don't ignore that. We say that for these purposes, that's not a relevant distinction. That may relate to a difference in remedy between the personal action and the derivative action, is that under the personal action, the claimant is seeking to recover only his own loss. Under the derivative action, he is recovering the estate's loss, and to him will percolate a sum of money which will quantify his own loss. The mere fact that that money goes into the estate, and the estate will in due course of its own internal workings distribute the assets, we say is not a material distinction.
Are you going to say something at some point about the, I just see the reference that Lord Millett made in paragraph 74 to the need not to prejudice creditors, because there's still a very large sum due to the estate duty office, is there not?
There is.
With 14 years interest now. I mean, that presumably has priority to the claims of all the beneficiaries, is it?
It will do. As I understand it, the government takes its slice first, whatever the parties may wish to do amongst themselves, and that will remain. Because a derivative action is brought in the shoes of the estate, a beneficiary who does it may hope that he will achieve benefit when the action is finished and there has been distribution, but he cannot guarantee it. He cannot put himself above creditors because he is simply enforcing the estate's right to get its asset in.
If it's the same cause of action as the existing cause of action, why isn't the position exactly the same, even if a duty is owed directly to the shareholders? So insofar as it's not a derivative action, but nevertheless a claim, the principles of reflective loss apply to it.
Yes.
So it's not quite clear to me why the position is any different as between the two, on your analysis.
My Lord, it is a question of remedy. If there is a personal claim, the basic rule is that the claimant is entitled to recover his loss only, and that's quantified through what would happen to the recovered money, what would happen to the recovered assets had they gone to the estate, had performance occurred properly, the estate would have benefited, the estate would not lost, and there would have been a distribution. We say that in terms of outcome, the outcome for the claimant is exactly the same in practice. In the case of a personal claim, the court may have to assess what that outcome will be. In the case of the derivative action, the outcome will be produced by the actual administration of the estate. But assuming the court's assessment is correct in a personal action, the outcome will be the same. There won't be a difference in respect of the claimant's final position, nor will there be prejudice to creditors.
If this had been a company claim and the solicitors for the company had failed to ensure that the managing director had set aside enough money to pay dividends and so on, a personal claim by a shareholder would have been hopeless on the basis of the reflective loss principle.
Yes. Yes, it wouldn't have got very far at all. Quite right. Lord,
Is that all that you'd like to show us in Waddington, or is there some other passage?
Lord, I refer to Waddington, I think, a little later, but in respect to a different matter and a different passage. I wonder if I might come back to that in due course. I'm much obliged. Just responding if I might, to my Lord Collins' last point. Hopelessness of claims is, of course, it's perhaps a somewhat pejorative way of describing claims which have less than a good prospect of success. Again, we on this side have noted the respondent's approach to the original claim that was brought on behalf of the claimant. All we would say at this stage is this. As the Court of Appeal noted, and we would suggest rightly noted, despite the length of time in respect of which that claim had been on foot, there was no application to strike out or dismiss on the basis that it was hopeless. When the matter came before the court to amend, there was no application to strike out on that basis. The Court of Appeal considered the claim on the basis that it was an arguable claim. Insofar as we have analysed the rights and wrongs of the situation, in this case, we accept that the general principle is that set out in Royal Brunei and Tan, which is that ordinarily a claim for direct loss suffered by a shareholder is, or indeed a beneficiary under a trust, is not going to succeed. But that is the ordinary case. It is not the case that in all circumstances one can conclude there is no duty owed. And indeed Johnson and Gore would. is a case in respect of which there was a duty found to be owing on the facts. So, whereas, my lords, I quite understand your lordship's comment, I would simply caution that the Court of Appeal certainly didn't go that far, and in reality the matter hasn't been before the court in respect of consideration of obligations or the factual background to entitle the court so far to have concluded that this was a hopeless claim.
But just on the damages, I'm still interested in the damages, yeah, because it's a bit unclear reading the way your clients have variously decided to put their claim for quantum, how they relate to one another. The old calculation may have been overtaken by new ones, I don't know. But why is the claim, as it stands at the moment, not a claim for reflective loss?
My lord, I think
how do you, it is?
It is.
Well, then it's hopeless. Isn't it? I mean, it's simply hopeless, unless you can say that you come within one of the exceptions to Johnson and Gore Wood, if there is an exception.
Well,
isn't that right? My Lord Collins is, with respect, correct. I mean, I quite see that it may not have been decided so far, but maybe it hasn't been thought about in as much detail as all that in the past. But once you concede that it is a claim for reflective loss, do you not equally have to concede that it's hopeless? Unless you can somehow set up at least some kind of colourable claim or arguable basis for distinguishing the principle in Johnson and Gore Wood.
Yes, you could say that there's a policy in relation to companies and the separate distinction between shareholders and the company and Salomon, and it's a special area.
Well, I could say that. My claim, my analysis is at the moment based on assimilation of areas rather than drawing distinctions between them.
Yeah, for the present purposes, you want it to be the same claim.
Indeed. My lords, if your lordships don't think this craven, perhaps I can answer the question in this way. At the moment, questions of hopelessness and otherwise prior to your lordships' inquiry, have always been considered on the basis of duty. They are in both cases, duty alone. Hopelessness as far as reflective loss and its exceptions are matters which have now been in play for 10 minutes.
But now you aver that these two claims are the same claim because they have all the same ingredients. And yes. The only difference is that the derivative claim is really the company's claim, but which can be advanced, as I understand it, in the name of the beneficiary. That's the only difference between them. In all other respects, they're the same claim. And of course, for limitation purposes, that's quite helpful from your point of view. Yes. But if that's right, then it follows that the claim for loss must be a claim for reflective loss and is actually doomed to failure.
Yes.
Of course, if you have some sort of coherent basis for saying that it isn't, such as one of my Lord's suggestions, I don't know, that might be different. But
well, I'm grateful for that suggestion.
I'm not suggesting there's anything in the point. I'm just rather mesmerised by the whole thing.
Well, I'm rather hoping, as I say, if it won't be thought craven, that's something I might consider over lunch. And I will respond to the matter. It's not an attempt to duck out of your lordship's question. But as we'll see, certainly in some of the cases, even if it were the fact that a claim was hopeless for, I won't say a procedural reason, because Johnson and Gore Wood is actually a rather substantive area of law, but if it was hopeless for a substantive reason, that wouldn't affect the same cause of action argument. The recent case we'll look at, I think in due course, Parkinson and Swan, is a case in respect of a claim brought by a company which had been in administration, gone to liquidation, but tried to sue its liquidator. And of course the claim was hopeless because the liquidators had been released and the court had not made an order, indeed could not make an order in the company's action, requiring the administrator to repay. The liquidator then sought to bring a claim outside the limitation period. The Court of Appeal said, no, it's actually the same claim, not a problem, even though we're substituting parties, same cause of action. So, my Lord, whether or not at 2 o'clock I stand up and say, yes, having taken that point on board, hopeless it may be, it's not a point that I say is going to be material to the outcome of the appeal, interesting though it is. difficult that may be. So, my Lord, if I might pause matters there, I apologise not to take it further.
I think the indication is we can look forward to 2 o'clock, but move on meantime and see what happens.
My Lord, so returning to the derivative claim as we've defined it, this is at paragraph 2.4 of the case. Although anybody, we say, with a sufficient interest in the relief that might be granted has a standing to seek equitable relief to protect their interests, the general rule, as a matter of procedure, is that that person should bring some form of proceedings for the court to determine if and how any claim should be made. And if one considers it, that's an understandable mechanism, because we're considering derivative actions, which by their nature are out of the ordinary and do not follow the usual procedure whereby the legal owner brings his claim.
That proposition would hold good in a case where you're not seeking to amend anything. You're simply making this as the first step in the litigation. You're taking a derivative claim as your first and only step.
Yes.
You would need to go through this procedure as a matter of good order and proper discipline.
Indeed. And if one looks at the ways in which courts have considered how these matters can be dealt with, one sees some degree of uniformity. As far as an estate is concerned, a beneficiary who is dissatisfied could bring some form of administration proceedings. In a claim relating to a trust, ordinarily, it would be in the form of an application to require the trustee to execute the trusts. And in the case of an equitable assignment of contractual rights, it would take the form of an application to oblige the legal owner to sue. In the divided world of legal rights and equitable rights, those are examples of the equitable right alone being enforced without enforcement of the legal vested right. In any such application, the court would have to consider whether the legal owner was obliged to act and had failed to do so. And so far I've mentioned administration proceedings, trusts, and contractual rights. There was no analogous procedure relating to shareholder actions, obviously because shareholder actions are relatively recent concepts, but also because shareholders had contracted to allow the decision to enforce a legal claim against a third party to be made by the company. In other words, that's simply part of the shareholders' deal amongst themselves and with the company as a corporate entity, that decisions will be made by the company, either acting through its board, where appropriate, or acting through general meeting. And as far as that was concerned, the company had there was a separate remedy against the company if the shareholders were dissatisfied with its decision-making, and that would either be to try to persuade it to change the officers or change the decision by general meeting, or in extremis by winding up. Now, there was a lacuna in respect of that model of corporate governance, and equity was obliged to fashion a remedy in circumstances where the decision-making mechanism had broken down for improper reasons, and that constituted the exception to the rule in Foss and Harbottle. And it did so by analogy with its power to prevent wrongdoing as regards legal rights. And I've referred, my lords, to the well-known decision of Foss and Harbottle, Vice-Chancellor Wigram, and also a citation from my Lord Collins' judgment, first instance in Conor Mananey and Rolls-Royce India Limited.
Do you have a reference in the bundle to where we find Lord Collins' judgment?
Yes, it's volume 3, the authorities, authority number 32.
35, I think.
35, I'm sorry. Oh, yes. Tom. Lords, I've referred to paragraph 28 of my Lord Collins' judgment. Can I ask your Lordship simply to note in also a reference to paragraph 25 of my Lord's judgment? Perhaps helpful to start there. Having set out the rule in Prudential at 24, his Lordship said this, the usual rule is that a company is the proper claimant in an action to redress a harm done to the company or to enforce a cause of action vested in the company, the so-called rule in Foss and Harbottle. There are, however, a number of exceptions to the rule. The exception relied upon in this case is an alleged fraud on the minority. The remedy was introduced on the ground of necessity alone in order to prevent a wrong going without redress, and the reference to the judgment of I think it was Mr. Justice Knox in Smith and Croft number 2. Where what has been done amounts to a fraud and the wrongdoers are themselves in control of the company, the rule, that is the rule in Foss and Harbottle, is relaxed in favour of the aggrieved minority, who are allowed to bring a minority shareholder's action on behalf of themselves and all others. The reason for this is that if they were all denied that right, the grievance would never reach the court, because the wrongdoers themselves, being in control, would not allow the company to sue, reference the Court of Appeal's decision in Edwards and Halliwell and Prudential Insurance. As Lord Justice Brown Wilkinson, as he then was, said in Nurkham and Nurkham, since the wrong complained of is a wrong to the company, not to the shareholder, in the ordinary way, the only competent plaintiff in the action to redress the wrong would be the company itself. Where such technicality would lead to manifest injustice, the courts of equity permitted a person interested to bring an action to enforce the company's claim. His Lordship then considered certain aspects of the exception to the rule in Foss and Harbottle, paragraphs 26 and 27, and then continued at paragraph 28. For present purposes, the following propositions may be derived from the modern cases. 1. Since the bringing of the derivative claim requires the exercise of the equitable jurisdiction of the court on the grounds that the interests of justice require it, the court will not allow such an action to be used in an inequitable manner so as to produce an injustice. See Nurkham. 2. Accordingly, a claimant who has participated in the wrong of which complaint is made will be disqualified from bringing the action, referring to Gower's Principles of Modern Company Law and the judgment of Lord Justice Lawton in Nurkham approving that. And thirdly, the claimant must be acting bona fide for the benefit of the company. Nurkham and Nurkham, Barrett and Duckett. And of course, that the claimant must be acting bona fide for the benefit of the company is one aspect of the proposition that the fruits of the litigation accrue to the company and not to the claimant. My Lord, it's right that at the instance of any person with standing by way of sufficient interest, a court of equity has always been able to grant relief, such as injunctive relief, directly against the defendant. And I've referred to the old cases cited and explained in Ingle and Moran that illustrate that a beneficiary may take action to protect an estate before an administrator is appointed. Now, Ingle and Moran is at authority number 32 in the same bundle. It's right to say that this case has been described as a blot on English jurisprudence, and indeed the effect of it has been reversed by statute. But the facts are unfortunately material. It concerned a fatal road accident when the father of the deceased, who was the plaintiff, issued the writ. But at the time that he did so, he had not taken out letters of administration to the estate of his son. He took out letters of administration subsequently, and that was indeed more than a year after the date of the accident. And at the time, the relevant limitation period in respect of fatal accidents was 1 year. So he only constituted himself an administrator outside the period of limitation. Lord Justice Scott delivered the leading judgment on appeal from a decision of the county court which had found in favour of the plaintiff. And if I can ask your lordships to turn to page 164. Perhaps it's best if one looks at the starting part of Lord Justice Scott's judgment, where his lordship set out the arguments that were raised in this case. Page 163.
Yeah.
Before us, this is about 8 lines down from the top, there was no appeal on the issue of death through the defendant's negligence, but the defence raised 2 pleas which were fully argued. First, action never properly constituted, and that while it purported to be a representative action by the plaintiff as administrator by writ issued on the 17th of September, in fact, the grant of letters of administration was only on November 13th following. 2, alternatively, that even if the action ever became well constituted by the grant in November, that was too late, as it was not commenced within the statutory period of 12 months from the accrual of the cause of action, as required by the Limitation Act 1939, section 21. The plaintiff sought to answer both pleas by the contention that the plaintiff's title related back to the death of the intestate. His lordship commented that he agreed with the analysis of the cases cited of Lord Justice Goddard. The basis upon which his lordship's judgment appeared to pass is that set out, starting at 164, about 15 lines from the bottom, the sentence starting, such an action. Such an action was, in my opinion, incapable of conversion by amendment into a valid action, just as so much as if he had issued a personal writ, claiming to be lawfully possessed of the estate of the deceased, and had subsequently asked leave to amend by substituting a representative claim. It's true that when he got his title by the grant of administration, he prima facie become entitled to sue, and could then have issued a new writ, but that was all. An application by him to treat the original writ of September the 17th as retrospectively valid from that date would have been refused by the court, not only because it might prejudice existing rights of defence, but because it would not be permissible under the rules of the Supreme Court or the Judicature Acts. The old writ was, in truth, incurably a nullity. It was born dead and could not be revived. If that conclusion is right, it follows equally that the statement of claim was not delivered in any action recognised by the rules of the Supreme Court, and all subsequent proceedings in the supposed action, including the judgment of the learned county court judge, were likewise nugatory, for if the action and the pleadings were bad, there was no valid action for the learned judge to try, and it is our duty to say so. So, my Lord, Lord Justice Scott decided the case on the basis that this was, perhaps in the language of my Lord, Lord Collins, not only a hopeless case, but a case that was a nullity from the outset, and hence could never be revived under any circumstances. My Lord, if one passes on to the judgment of Lord Justice Goddard, who considered the old cases that he had been referred to in the course of hearing, his lordship analyses those, I think the exegesis of the analysis is at pages 171 to 172. Well, the conflicting opinions as to whether one could sue without letters of administration having been issued were those, it appears, from the yearly practice and an unreported case of Mr. Justice Phillimore in Chambers, which was cited. His Lordship, at about halfway down page 171, said this: "In my opinion, the decision of Mr. Justice Phillimore was right, and the statement as to what may be done in the Chancery Division is too wide. It is enough to refer to the cases which are cited in Daniel's Chancery practice as authority for the propositions stated: Felon Lutwidge, Humphreys and Humphreys, Horn and Horn. All these cases were administration suits or suits relating to the administration of estates. They show that actions brought by persons who would be beneficiaries in the administration are not defeated, either where the person entitled to letters is plaintiff or where such person is made a defendant, because the grant has not been made at the date of the writ. The action is brought to protect the estate. The modern practice would be to issue a writ asking for the appointment of a receiver pending a grant of letters, and if brought by a person who would be a beneficiary in the administration, there would be no objection to the action, because the person entitled to take out letters is, and must be made, a defendant of the grant that has not yet been made. It's true that in Felon Lutwidge, Lord Hardwicke, the Lord Chancellor, but who would also have been a Lord Chief Justice of the King's Bench, gave as a reason for an action at law not being maintainable by a person who was merely entitled to administration, that he would have to make profit of the letters, and that was not required in a court of equity. But I do not think he meant to lay down that in any chancery suit it was open to a person to file a bill as administrator before he obtained a grant, and if he did, it's contrary to the later authorities. Of course, filing a bill was the subject of that comment. Evans and Bagshaw, Attorney General and Corporation of Avon, both suits in equity are directly in point, but it's unnecessary to go through the many cases to cite in argument, because, in my opinion, it's the plain duty of the court to follow the Privy Council case of Chetty and Chetty, and that's conclusive on this case, on this point.
I'm not quite sure what we're to get out of this case. I'm looking at paragraph 2.5 in your written case. Is that really explaining what we're to take from it, that the beneficiary may take action to protect an estate before an administrator is appointed?
Yes, it is.
And how does that help us in this case?
Laws, he's taking his, the Court of Equity would recognise an entitlement on the part of a beneficiary in these circumstances to bring a claim which would affect the person who was alleged to have done the legal wrong. Let's put it that way. Now that, under these old cases, would only have been an interim remedy because it would have been holding the ring pending the grant of administration. But what it does demonstrate is that equity would allow a beneficiary to take steps that affected the legal right, even though there were no letters of administration, and indeed even though in those circumstances the legal estate would have been vested in whoever it was vested in 1944 if there had been no letters of administration of the estate. I'm afraid that the proposition is really as limited as that. It doesn't purport to go any further than that. It simply demonstrates that equity would allow a right for those limited purposes in those circumstances. Lord, whether it be a case of taking protective steps, or whether it be a case of bringing a derivative action, or more widely, bringing a claim in equity in respect of contractual rights, the Court of Appeal have referred to. What happens here, is that a Court of Equity grants relief in respect of the same cause of action. This is the point. There is only one cause of action. And that cause of action gives rise to a right of action which is vested in law in another, that is the legal owner. And we would suggest that that principle can be seen in operation in the context of the enforcement of contractual rights by an equitable assignee. And we have referred in our case to the decision of Mr. Justice Scott, as he then was, in Weddell against Pearce and Major, that is volume 5 of the bundle of authorities.
I may have got something, maybe going back to the point we raised earlier. Do you accept there's only one cause of action?
Yes.
Is it common ground?
I'm afraid I can't answer for my learned friend. He may be nodding vigorously as your lordship asks me. I'm not sure, or not. We say there is one cause of action, and it's being enforced by different people.
You say there's only one cause of action.
Yes. Lord, when there is perhaps I can express it this way, when there is a derivative action, necessarily one is enforcing the same cause of action as the legal owner has. In those circumstances, there is only one cause of action.
I mean, is there a significance in the words "the same cause as the legal owner has," or are you just enforcing the legal owner's cause of action, being the only one which is available?
Yes, and in my submission, there is a distinction between what one might describe as the title to the cause of action and the title to sue. The cause of action vests in the lawful owner. He's the person who has it as, if one wanted to refer to it as specific property, that would be vested, and use that word, in him. Simply because he has that cause of action does not mean that he is the only person who can enforce it. As your lordship says, it might be right to say that the claimant in this case is seeking to enforce somebody else's cause of action. That's a perfectly acceptable use of language that people can understand. But it's necessary to understand that, as otherwise one errs in thinking that different claimants suing in different capacities are suing in respect of different causes of action. They're not. They're bringing claims in respect to the same cause of action. Let's see. My learned friend Mr. Adams has reminded me that in our case there is reference to authority which describes what is meant by a cause of action, and we deal with cases like Latang and Cooper, indeed judgment of I think Justice Brett going back many years. The concept's one which is known to lawyers, but certainly in more recent years there has been concern expressed that cause of action itself may be an ambiguous phrase. It may not be capable all the time of precise identical meaning in different contexts.
Where do we have this set out in the case then? Mr. Adams was referring to a particular paragraph, was he?
Yes. 319.
219?
3.19, my lord.
3.9.
Yes, thank you, Tom. My learned friend also refers me to 3.18, which is right.
Yes. Well, are you coming on to develop this at a later stage in the argument, or would you like to expand
I'm more than
on it
happy
now?
to do this now if your lordships would wish me to do it
Well,
now.
I think it would be helpful since we've reached the point.
I'm grateful. Perhaps, my lord, if one then takes a step back, because we to 3.17. A cause of action has traditionally been defined as simply a factual situation the existence of which entitles one person to obtain from the court a remedy from another person, and reference there to the well-known judgment of the Court of Appeal, Latang and Cooper, that's from Lord Justice Diplock. If your lordships wish to refer to that, that's authority 37 in bundle 3. Your lordships may recall that that is a case, it was a running down action in which the claimant had sought to phrase it as a case of trespass to the person in order to obtain the benefit of the 6 years limitation period that accrued, rather than the 3-year limitation period that accrued in respect of personal injury claims. And the passage that has been cited in many subsequent cases at 242, it's the judgment of Lord Justice Diplock, where his lordship started, a cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. That's the bald statement of principle, and then the explanation as to how that was then applied to the traditional systems of pleading, to the effect of the Judicature Act, and the consequences of that. But perhaps it's worth looking at that page as a whole. Historically, the means by which the remedy was obtained varied with the nature of the factual situation. The causes of action were divided into categories according to the form of action by which the remedy was obtained in the particular kind of factual situation which constituted the cause of action. But that is legal history, not current law. If A, by failing to exercise reasonable care, inflicts direct personal injury upon B, those facts constitute a cause of action on the part of B against A for damages in respect of such personal injuries. The remedy for this cause of action could, before 1873, have been obtained by alternative forms of action, namely originally either trespass viet armis or trespass on the case, later either trespass to the person or negligence.
Are we to take it from the way he phrases it, letter B, that the damages form part of the cause of action?
The damage forms part of the cause of action. I'm not sure the damages do.
So there must be damage in order to complete the grounds on which an action may be brought.
If the cause of action is one that requires it, yes. And if one's suing in trespass, for example, that's actionable per se. You don't need to show damage in order to constitute your cause of action. A breach of contract is actionable without proof of damage. Tort, on the other hand, negligence, nuisance does require damage. So, yes, in certain cases, that element of fact is a necessary ingredient to have a valid legal cause of action. No doubt about that.
It's odd though, isn't it? Because you couldn't just aver those facts and say in the premises the claimant is entitled to recover from the defendant, could you? Because that's much more complicated than that. I mean, if your claim is in negligence, you've got to allege a duty of care, and then you'd have to allege the factual situation which gave rise to the duty of care. So that Lord Justice Diplock's analysis is okay so far as it goes, but it's really quite simplistic in the modern day, isn't it?
Well, my Lord, I would agree with your Lordship to this extent, that in view of the discursive and informative nature of modern pleadings, if a pleader were to simply set out the facts and not assist the other party in the court by saying, I claim in negligence or a duty of care.
No, but it goes further than the discursive nature of modern pleading. These are essential averments. In many cases, it's perfectly obvious that there's a duty of care owed, like the man who's damaged, injured in a car accident. So obviously they can all be taken as said. But actually, as a matter of analysis, it's much more complicated than Lord Justice Diplock suggests.
I mean, he does actually, letter F, come on to introduce the element of reasonable care, which begins to make put a little more colour onto the proposition, as if there isn't any real distinction between what he's talking about.
Well, that's right. As his lordship having dealt with causes of action and forms of action, says, if A, by failing to exercise reasonable care, inflicts direct personal injuries upon B, it's permissible today to describe this factual situation indifferently, either as a cause of action in negligence or as a cause of action in trespass. And the action is brought to obtain a remedy for this factual situation as an action for negligence or as an action for trespass of the person.
And that's because one treats the duty of care as red.
Yes.
And merely causing damage to another, or loss to another by negligence or by failure to exercise reasonable care, is only one small step along the way in very, very many classes of case. Of course, in the personal injuries case, it's obvious, perhaps, but in many other kinds of case, and ours might be one, it's...
My Lord, well...
I mean, take this case. In the averments in the first, in the claim as presently stands, are A, owed a duty of care to B, and B has suffered loss as a result.
My Lord, if one strips out all of the other facts, those two averments are indeed left standing. Yes, that's certainly one issue which indeed this appeal raises, and that is whether if someone says these facts occurred in this situation, sets them all out, and as a consequence, and you owed me a direct duty of care, whether he's setting up a different cause of action from the derivative action which extends to the cause of action of loss to the estate. Well, that is an issue. It's undoubtedly an issue.
And your answer to that question?
It doesn't. That the cause of action is based on the factual circumstances. That the factual circumstances here are that there is a retainer between the defendants and the estate, that that retainer contains certain obligations, that there was a breach of that retainer and negligent activity, breach below a certain standard, the duty of care, damage was caused, that we are the beneficiaries to that claim. Our assertion that we were owed a duty of care tacked on to that, one might say that's simply a misunderstanding of the legal relationship between the parties, because you have drawn the wrong inference from the facts that you have pleaded. It's not in those circumstances.
But I can see that, if your claim is and is only a claim for the reflected loss of the company.
Yeah.
Because then you can say with Lewis, I suppose, that this is a claim brought in the name of the, as an alternative to proceedings brought in the name of the trustees, a beneficiary may sometimes bring an action in his name on behalf of the trust against the third party. That's how Lewis describes this class of claim. And are you saying that that describes the action as at present formulated?
Lord, I don't think I can do that. The action as presently formulated asserts, there is no doubt that it asserts, a personal claim, because it says, you owed me a duty of care. It's, well...
Generate a different cause of action.
No, my Lord, I'm afraid that I don't agree with that. Maybe we will not agree, I don't. The pleading is in respect, the pleading asserts all of the material facts. It sets out the relationships, it sets out what happened, it sets out what went wrong. It asserts a legal relationship between two parties that is in error, in all likelihood. If that is right, pleading a different legal relationship from those same facts is not pleading a different cause of action. It's relying on the same cause of action but raising a different claim.
In other words, you say that you should be treated as though you had simply sent out the relationship between the solicitors and the estate, the person acting for the estate, and said nothing else. Is that right?
Well, yes, should be treated as if, I think is probably a fair way of putting it. If one is looking, if one imagines...
You don't need leave to amend at all.
My lord, I suspect that if that's your lordship's conclusion, I'll rest content. My lord, the position is that if one considers what happens when the matter gets to trial, what's going to be argued about, what is going to be argued out is the factual relationship between the parties, what the solicitors did and what the consequence of their actions were. The lawyers may then argue about whether against that background there were legal rights direct between the solicitors and the claimant, or whether there were not, whether the claimant in fact has to get his legal rights, whether it's in respect of the same or reflective damage, no doubt a matter for discussion, by way of using the estate's claim. But the court would be considering exactly the same factual matters. Now, if it is a consequence that if that is a blunder, if it's a blunder that causes a totally different legal thing, a different cause of action, with the result that certainly 3 courts have had to consider the rightness or wrongness of the application. In my submission, that would be unfortunate, bearing in mind that the solicitors are not going to be considering any different case, any different factual case from the one asserted.
Is the individual standing to bring the claim part of the cause of action? Because, I mean, if you narrate the basic facts, that still leaves a gap, at least as I see it, as to why you're here. What is the standing which you assert? And it applies to the personal claim as much as to the derivative one.
Yes.
And they appear to be different, which is why one wonders whether the causes of action really are the same. But would you accept that standing is part of it?
My lord, no, I wouldn't accept that. The cause of, if one considers any derivative action, the cause of action is the, I think perhaps here's where we come back to terminology. The cause of action is vested in the legal owner. Yeah. That's the cause of action. If one is considering many different causes of action, a cause of action vested in the legal owner, a cause of action vested in the equitable owner, then your lordship's analysis may have flaws. But in my submission, that's not the right analysis. The right analysis is one cause of action, various people who can claim, and it's entitlement to claim that relates to standing. And this comes back to Prudential and Newman, all the derivative action cases. The claimant is in those circumstances enforcing somebody else's claim. It's his cause of action if you view it as a matter of property.
Yeah, I see that you say that Lieutenant Cooper was approved and so on. I have a sort of recollection in the back of my mind that quite a lot of people have written very critical things indeed about the Court of Appeal decision in Lieutenant Cooper, which, I mean, to say that to say that it's a matter of indifference and so on, whether you call something trespass or whether you call it negligence, and that there aren't 2 causes of action, I mean, really, it's quite difficult, actually.
A matter of indifference, I'm not sure I'd go that far. If one is, according to Lord Justice Diplock, your factual situation gives rise to one's legal remedy. Of course, if you call something trespass and you don't assert the necessary interference with possession, one may have difficulties. You may get home on negligence, but you may have to make it clear to the other side that's what you're doing, and the court has to be willing to consider the case as being advanced if there's a change of case. There's no prejudice, for example.
All Lord Justice Diplock was saying is you don't plead law, you only plead facts.
Yes.
Now, today, of course, the expression cause of action is still in the Limitation Act, but it's no longer used, I think, in the CPR, is it? The expression is claim.
That's right.
So how relevant is all this old learning on pleading today?
My Lord, it's unfortunately relevant for the very reason that your Lordship indicates, that it is still used in the Limitation Act. The Limitation Act talks about claims, it talks about new claims, it talks about causes of action. Insofar as those are different, then clearly they have to be given a meaning. And although in practice one uses different, perhaps more precise terminology, when one is seeking to apply the statute, one has to work out precisely what those concepts mean.
Isn't it an essential, assuming the old law still subsists, and you have to plead facts only and not law, still, in the case of a derivative action, you would still have to show, as a matter of fact, why this is an appropriate case for a derivative action, wouldn't you?
My Lord, I think not. You would probably have to show it, but you probably wouldn't have to plead it. The question is whether undoubtedly you will plead it, because any applicant knows what's coming in terms of
In this case, it isn't pleaded, is it? In fact, this case is not really pleaded as a derivative action, although it's got the heading of one. It's still an action for his third, isn't it?
Yes. My Lords, the Court of Appeal were happy to deal with the matter as a derivative action. That's how the appeal's been subsequently been dealt with. If your Lordships are concerned that even the pleaded amendment does not disclose derivative action, and we're raising perhaps more detailed and different points
Well, I
than
don't
those
think
we've
it does.
come to discuss.
That's page 49 of the appendix.
Perhaps the way to put it is this, that ordinarily it's no business of the defendant whether the action is a derivative action or not. As I apologise for moving from the cause of action section of my case back to the derivative. Back to the derivative action section of the case. We submitted that because a derivative action is an unusual course of action, there had to be some mechanism whereby threshold tests of entitlement to bring the action could be considered. And those were matters that related not to the defendant, the person who's killed the deceased, or the solicitor in breach of his dealing with the estate. It doesn't relate to him. It relates to internal management of the claim itself, whether the trustees or the executors should be entitled to make the decision, or whether somebody else, a beneficiary or a shareholder in the company case, should be able to make it. So the derivative aspect of it, that part of it, is a part that really isn't a matter for the defendant. So perhaps the answer to your Lordship's question is no, it's not a necessary element of the claim that the derivative nature of it be pleaded. What happens subsequently, as the case sets out, is that the defendant may say, well, I have a practical interest in ensuring that matters are dealt with in a certain way, and therefore, by way of procedure, you get joinder of the legal owner, possibly joinder of other beneficiaries. But that's not a cause of action element, that's an administration, management element. Lords, having said that, if I can come back then to deal with the cause of action point that we were looking at. Lords, we've looked at Latang and Cooper cause of action. My Lord Lord Collins referred to cause of action as being referred to in respect of Section 35 of the Limitation Act, and it was considered in the case of Paragon Finance and Thakrar in that context, and that's Authority 47 in Bundle 4. Starting at page 405, in fact, letter D, it's section 2, amendments which the plaintiffs contend do not introduce a new cause of action are not objectionable on other grounds. The classic definition of a cause of action was given by Mr. Justice Brett in Cook and Gill. Cause of action has been held from the earliest time to mean every fact which is material to be proved to entitle the plaintiff to succeed, every fact which the defendant would have a right to traverse, my emphasis. In the Thakrar case, Mr. Justice Chadwick cited the more recent definition offered by Lord Justice Diplock in the Tang and Cooper and approved in Steamship Mutual Underwriting Association against Trollope and Coles. Cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. I do not think that Lord Justice Diplock was intending a different definition from that of Mr. Justice Brett. However it's formulated, only those facts which are material to be proved are to be taken into account. The pleading of unnecessary allegations or the addition of further instances or better particulars do not amount to a distinct cause of action. The selection of the material facts to define the cause of action must be made at the highest level of abstraction.
The way that paragraph is expressed suggests to me that a great deal depends on the context in which you're asking what is the cause of action, for what purpose. And for purposes of pleading, I can see all you need are the material facts and you discard the rest, and if somebody complains that you haven't pled X, Y, or Z, you could say, well, they're not part of the cause of action and therefore I don't need to plead them. I can follow that.
Yes.
But it doesn't mean to say that every time you use the phrase, that formula exhausts what you're talking about.
My Lord, it is right that judges have queried the consistency of the use of the phrase cause of action in different contexts. That is undoubtedly correct. The question in connection with this application related to amendments to plead fraud, conspiracy to defraud, fraudulent breach of trust arising from negligent acts by solicitors in respect of mortgage cases. The question was whether there was an entitlement to raise that in the context of what was RSC Order 20 Rule 52A, which related to the joinder of new causes of action outside of the limitation period. So this is a considered opinion as to the meaning of cause of action in the context, in the limitation context. And I do rely on this as being helpful authority to the effect that in this case, the phrase cause of action, the limitation context, does bear the Latang and Cooper meaning.
I mean, here in order to for you as plaintiff to succeed, you would have to plead things which you wouldn't need to plead if you were there simply as the company, if it was simply the company bringing the action.
Yes. We are obliged to plead that we're entitled under the estate. We're obliged to assert our standing. That's not a matter of our cause of action, though. That's a matter of simply showing that we have a right to bring this claim.
So you don't include standing in
the cause of action, I don't. No.
So when everyone has said that which is material proof to entitle the plaintiff to succeed, you would say that doesn't actually apply in this situation.
It doesn't. If one's simply asking what is the cause of action that must be asserted. It is right, however, that if one does not indicate one's standing, in other words, if one says nothing more than I'm a member of the general public and a wrong was done to X, then your claim is going to get struck out. But it's not in those circumstances, it may be necessary to plead that fact to show your standing. It is not necessary to plead that fact to show that you have a cause of action. You don't. It's necessary to assert that fact to show that you can enforce somebody else's cause of action in a derivative claim. Lord, I refer to difficulties that have arisen in connection with the definition of cause of action by reference to the case of Smith and Hennigan Major. That's Authority 56.
You're helped actually by the new provisions about derivative claims by companies, because I note from the White Book that Section 260 of the New Companies Act provides a new and exclusive statutory definition of a derivative claim, namely proceedings by a member of the company in respect of a cause of action vested in the company.
Yes. Well, that is right. That's how statute views it. I'm not sure whether your lordships view this appeal as an opportunity to correct the taxonomy of pleadings and litigation. It may be that that's something which the parties, that litigants can be left to deal with themselves over, no doubt, many more years, as they have done in the past. But one of the problems that arises in connection with statutory interpretation of Section 35 is, as my Lord Hope says, context can affect meanings. And we have the concepts of, in limitation, of a cause of action, a claim, and a new claim. And we say that those are, especially as far as claim and cause of action are concerned, they are different things.
Sorry, I missed that. Different
things.
Different things.
They will normally coincide because the normal person to enforce the cause of action is the legal owner. It's his claim. Normally no problem. A problem only arises where you have someone else, someone entitled in equity or somebody who has an equitable right to enforce, bringing a claim in respect of a cause of action. And whether we call those derivative actions or call them something else, it's just a label. But that is what they are doing.
This question of whether these are two or one causes of action is only relevant, is this right, in relation to the provisions of the Limitation Act?
Yes, because that's...
It isn't really relevant to what you should put in a pleading. Because I'd have thought these days, in the statement of your case, you had to make it clear what your case was. And if we look, which to my mind is the most helpful definition of a derivative action, is in the bit in Lewin on Trust, which is quoted by Lady Justice Arden in her judgment, which I don't understand anybody to disagree with. I mean, he says, as an alternative to proceedings brought in the name of the trustees, a beneficiary may sometimes bring an action in his name on behalf of the trust against a third party. Now, that's the nature of a derivative action.
Yes.
And surely your pleading, as a matter of pleading, should state it. Because I'm bound to say, when I read the statement of claim, the unamended statement of claim, it didn't occur to me that what was being pleaded was what is described by the editors of Lewin on Trusts. And I rather agree with my Lord Wood Collins, and I'm not sure you relegated out of the amended statement of claim, particulars of claim either, but leaving that on one side, we know that the purpose of the amendment was to plead such a claim. But Lewin now describes the position correctly, doesn't he? Perhaps he doesn't, I don't know.
Well, I don't, again, the sin of definitions is that they may be correct insofar as they go, but they may not be helpful as regards the issue that one has to consider.
I understand that. I'm not asking you about the meaning of cause of action, but he correctly describes the nature of the claim you're advancing in a derivative action. And as far as I can see, consistently with your submission.
Well, in that case, my lord, who am I to differ?
Well, I might be wrong about that.
If one breaks it down, the beneficiary, so the third party in equity, brings an action, yes, it's his action, he's the person whose name is on the writ, it's in his name, that's right, it's on behalf of the trust, so he's bringing a claim for someone else to benefit someone else, which he will benefit indirectly. My lords, I would agree with that. That seems to me to be right.
And moreover, in respect to the trust's loss, because that's the only class of claim that he can bring as a derivative action.
Yes, that's certainly true.
So if it is a derivative action, that is undoubtedly the end of your first action, because he could only be bringing a claim for reflective loss as a matter of analysis.
My lord,
I know we'll come back to that. As far as I can see, that is it's very difficult to get away from that, and that may be okay from your point of view, since it looks pretty hopeless, your case anyway, the individual duty case. So then you could say, oh, well, there it is, that was what was there, and what we're now trying to add on is actually no different, not in terms of cause of action at least, so we're okay under Section 35. I can see you can say all that.
your lordship puts it better than I.
Well, it's right, I don't know.
I'm sorry, my lords. Yes, I was. I'm sorry, my lords. I think I referred to Smith and Henniker Major. And Smith and Henniker Major.
Yes.
It's authority 51.
Volume 1.
Volume 4.
51.
51, volume
51.
4. No,
No.
I'm sorry, I managed to turn over 2 pages. Sorry, my lords.
56.
56. I've gone back to the cause of action.
56, yes.
Thank you, 56.
Where would you like to go in the case?
Well, my lords, it's being cited for the query over cause of action. Indeed, this was a case in which my Lord Walker delivered a substantial judgment.
I delivered a very long judgment with which neither of my brothers agreed.
Well, I don't think that's wholly right, my Lord. I think they only disagreed on one point. If your lordship could go to paragraph, I think perhaps 94 is a convenient place to start.
Judgments tend to be disagreed.
Which paragraph was it?
94, my lord. It appears from there that the judge concluded that the proposed amendment, this was again a case of an amendment in effect by a, yes, that's right. This was a case in, my lord, this was a case in which a company had purported to assign a cause of action to its director. The cause of action was cause of action by the company against professional advisors. The problem was that the director had assigned the cause of action to himself, being the only member present in a general meeting, because the wrongdoers, 2 other directors, had refused to turn up. The major one aspect in the case related to whether that assignment was valid or not, and the decision of the majority was that it was not. What had happened subsequently was that the claimant had executed a rectifying assignment, or a further assignment. And the question was whether he could now plead that further assignment from the company to himself or not. And that is the issue being considered in paragraph 94. On the other main point, Mr. Simmons defended the judge's conclusion that the proposed amendment would amount to the addition of a new cause of action, and that it did not arise out of the same or substantially the same facts as were already in issue. In reaching that conclusion, the judge referred to the classic and much quoted definitions of cause of action by Mr. Justice Brett and Cook and Gill as every fact which is material to be proved to entitle the plaintiff to succeed, and by Lord Justice Diplock and Natang and Cooper as simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. I have to say that in the context of Section 35 of the Limitation Act 1980, I am uneasy about the process of lifting either of these classic definitions out of the legal lexicon, as it were, and reading them into the language of Section 35(5)(a). The notion of a factual situation which arises out of the same facts or substantially the same facts as another set of facts is not an easy one to grasp. Probably the answer lies in Lord Justice Millett's observation in Paragon Finance and Thackeray that the selection of the material facts to define the cause of action must be made at the highest level of abstraction. So in identifying a new cause of action, the bare minimum of essential facts abstracted from the original pleading is to be compared with the minimum as it would be constituted under the amended pleading. But in applying Section 35(5)(a), the court is concerned on a much less abstract evidence with the abstract level with the evidence likely to be adduced at trial, see Good and Martin, approving Lord Justice Hobhouse's observation in Lloyds Bank and Rogers. The policy of the section is that if factual issues are in any event going to be litigated between the parties should be able to rely upon any cause of action which substantially arises from those facts. My Lord, the only point that I invite your Lordships to look at whilst we're on, further point to look at whilst we're on Smith and Henniker Major, is at paragraph 99. It's helpful perhaps to go to paragraph 98 before one gets there. The judge thought that the non-retrospective assignment affected by the 2001 deed, that's the second deed I've indicated, was part of the essential core facts which had to be pleaded for Mr. Smith to succeed in his claim. And that amendment to plead it was therefore the introduction of a new claim in the statutory sense. Just pausing there. So the judge took the view that the way in which the right to sue was vested in the claimant was a material part of the cause of action. Mr. Mabb has attacked that, relying particularly on what Lord Justice Evans said in Hendry and Chart Search, a case where there had been an assignment after the commencement of the action, but during the limitation period. The purpose of the re-amendment is to specify the reason why the plaintiff alleges that he is entitled to bring the claim. The cause of action remains the same. The additional facts cause no prejudice or embarrassment to the defendants. The judge did not regard that observation as binding him because it was not made in relation to the special problems raised by Section 35 of the Limitation Act 1980. I think he was right in that, and also that he was right to regard Robinson and Unicos Property Corporation as a case on special facts involving the changing members of a partnership. Although a claimant's title to sue cannot normally be regarded as the same as his cause of action, it's an essential part of his cause of action. I think the judge was right in his view that Mr. Smith had to bring the case within Section 35(5)(a). Lords, the most recent consideration of cause of action is to be found in the Harlan Wolff Pension Trustees case, a decision of Mr. Justice Warren last year, and that's at Authority 24, which is to be found in Volume 2. the relevant passages in this judgment are to be found at paragraphs 43 to 49 of the judgment. Most of this judgment, in fact, simply recites the authorities that we've already looked at. The material parts, perhaps, are these. Paragraph 43, meaning of new claim within the rule, that's 17.4, is clearly the same as a new claim within 35.2, and so envisages the addition of a new cause of action. The term cause of action itself, however, is not defined in the Limitation Act 1980 or the CPR. It can mean different things in different contexts. Then there's reference to the authorities that His Lordship has referred to by counsel. Got Cook and Gill, Latang and Cooper, Steamship Mutual Underwriting against Trollope and Coles, Paragon and Thakrar. Going over to paragraph 14.7. 48, His Lordship says this: even so, cause of action can be used in a different sense, which separates the concept of the cause of action from the facts giving rise to that cause of action. In this sense, a given set of facts can give rise to different causes of action. The present case provides an example. If Aon have been negligent, then the trustee has a cause of action in contract and a cause of action in tort. In other words, cause of action can be used in the sense of the juridical basis for the particular remedy sought in the context of the facts established. And then, while stating it's not altogether clear that the classic definition of a cause of action is entirely apposite in the context of Section 35, His Lordship comments that he shares my Lord Walker's unease expressed in Smith, Hennick and Major, sets out the relevant paragraph there. And then His Lordship goes on to consider the facts of that particular case. My Lord,
So that's a completely different meaning of cause of action.
well,
Not even related, really, to the
no,
to Lord Justice Diplock's meaning.
my Lord, this is cause of action almost in the sense of the old case of action.
Forms of action.
Forms of action, that's right. But it does appear from Mr. Justice Warren's comment at paragraph 49 that he wouldn't apply that meaning to cause of action where it appears in Section 35 of the Limitation Act 1980, but would apply my Lord Walker's analysis of Latang and Cooper as through Lord Justice Millett's observation in Paragon Finance and Thakrar. Lord, that deals with the definitional, I hope, definitional problem underlying cause of action. I wonder if I can come back to the question of derivative action that we seem to have parted from a little while ago. So
just so I'm clear, you've just looked at whoever it was, Mr. Justice Warren. You're not interested. You're not relying on 48, paragraph 48. I mean, just not quite clear what you say about 48.
Lord, as I read paragraph 48, it's relating to, as my Lord Collins comments, the form of action in trespass, a form of action in contract, a form of action in tort. I suppose they would both be actions. Would be both actions on the case? I don't know. It does appear to be a harking back to cause of action by reference to the legal pigeonhole that those particular facts form into, what you are suing in. Not a question of who is suing, it's a question of what you're suing for, whether it's contract or tort. It appears to be a use of cause of action in that sense, and I'm not suggesting that that's how you should use the cause of action in the Limitation Act 1980.
Well, it's a bit like a chameleon that seems to take on its colour from the surrounding context in which it's being used. And this is an example, isn't it, of that problem?
My Lord, yes, it's right. There's no such thing as an acontextual communication. Indeed, there's probably no such thing as an acontextual sentence or line in a statute.
So it's a sort of fluid concept.
No,
It's not a Lord Justice Diplock concept. I mean, are you approving or inviting us to follow my Lord Walker's analysis, quoted in paragraph 49, which is where Mr. Justice Warren seems to have left it.
My Lord,
That is the latest. That's the latest learning, as it were, on the document.
yes, it's Lord Justice
That's
Diplock.
to move away from Lord Justice Diplock and say, well, under the Act, it has to be construed purposely and so on. See, Lord Justice Hobhouse's approach in that case was proved in good and Martin.
My Lord, no. It's a, one could say it's a gloss on Latang and Cooper and no more than that. The sin, I think, and far be it for me to suggest my Lord Walker considered to be the matter, but the sin I think that Lord Justice Millett was warning against in Thackeray was the sin of saying that every single fact that you plead and assert as part of your cause of action is necessary for your cause of action. So if you change the facts, you change the cause of action. As I understand Lord Justice Millett in Thackeray, he was saying, no, what you have to do is you have to extract the essential facts. Once you have extracted the essential facts, that identifies your cause of action. Any other pleading around it that doesn't add to or vary the essential facts is the same cause of action.
But I mean, in Latang and Cooper, unless I misunderstood, the point was said to be that the whole point of the decision was that Lord Justice Diplock, in the end of the day, said these facts can only be described nowadays as an action in negligence. Because that was the way he got out of that's why he held that the thing was time-barred. Whereas if it had been described, as one might have thought it might have been described, as also equally well as being trespass, then it wasn't caught by the time bar.
No,
I mean, that was the whole point of the case.
It's not whether it's a negligence model, it's a question of whether it was an action for personal injuries.
No,
That
because
was-
it was, of course it was that.
Well,
But Lord Justice Diplock, as I understand it, says, no, it must be described as not as trespass, but as negligence, isn't it?
yeah.
Maybe wrong. I mean, I thought that's what he said.
My Lord, I think
It may say something else, but I was thinking it has 244. I mean, E to F, that is.
He was simply saying any claim for unintentional trespass was these days regarded as a claim of negligence.
if one turns to at page 244, Lord Justice Diplock, first of all, criticises the judgment below by commenting that the period of limitation varies according to the label that the judge puts on it, and then says this, the factual situation upon which the plaintiff's action was founded is set out in the statement of claim, and then sets out what it was. That factual situation was the plaintiff's cause of action. It was the cause of action for which the plaintiff claimed damages in respect of the personal injuries which she sustained, in respect of that. That cause of action or factual situation falls within the description of the tort of negligence, and an action founded on it, that is, brought to obtain the remedy to which the existence of that factual situation entitles the plaintiff, falls within the description of an action for negligence. The description negligence was in fact used by the plaintiff's pleader, but this cannot be decisive when we are concerned not with the description applied by the pleader to the factual situation and the action founded on it, but with the description applied to it by Parliament in the action in the enactment to be construed. It is true that that factual situation also falls within the description of the tort of trespass to the person, but that, as I have endeavoured to show, does not mean that there are two causes of action. It merely means that there are two apt descriptions of the same cause of action. It does not cease to be the tort of negligence because it can also be called by another name. An action founded upon it is nonetheless an action for negligence because it can also be called an action for trespass to the person.
I find that completely mystifying, to be
Yes.
honest.
It's much better put by Lord Denning at pages 239 and 240.
My Lord, I'm sorry, my Lord, if I'll turn to Lord Denning in a moment. The logical difficulty is that if you have a description which is encompassed within Forms A and Form B, why do you choose Form A rather than Form B? Why has Lord Justice Diplock alighted on negligence as the appropriate description for this factual circumstance rather than trespass to the person?
Because the claim was for unintentional injury.
He appears to have established a hierarchy of claim that if it was for intentional injury, it would only be for trespass to the person. If it was unintentional injury, it had to be for negligence, even though you could describe it as something else. I'm sorry, my Lord.
Yes, so the Act just said that actions for damages for negligence are 3 years.
And that's what it was. It may have been something else. It was that.
Yeah.
Yes. It's how he, my Lord, it's how he got there to describe the cause of action that's relevant for our purposes. My Lord referred to, I think, Lord Denning's judgment on page 239.
239, just at letter G, is it?
There's one thing that plays about stuff. It was trespass. I mean, that was clear. I mean, nothing could have been a greater trespass than colliding with the chap and injuring him.
Indeed, driving a car is a volitional action unless one's afflicted by
No doubt
automatism.
about it. But it was negligent, of course, which is, I think, the way
Yes.
that Lord Denning got round it.
Well, yes, Lord Denning's view is it, of course, it wasn't trespass, but it's Lord Denning's view.
Well, yes, that's what he's saying at F and G, isn't he?
Yes. Yes. I mean,
And there was also, around that time, I think, or a bit earlier, there was also some learning about whether a claim by an employee against an employer was in contract or in tort.
Romford and
Yes, Matthews and Kuwait, Bechtel, all those cases. And basically they said, you look at the facts and you decide, as a matter of law, what the type of claim is. And in those cases, they were held to be, I think, either in contract or in tort, depending on the context.
yes.
All this is relevant to what is it relevant solely for the purposes of construing the application of Section 35 of the Limitation Act?
35. My Lord, yes.
To some
No, that's it.
Yeah.
That's
So
it.
really we should go through the section
Yes.
Yes.
in order to see what it means.
Well-
and no doubt it'll be distracted by this jurisprudence.
Well, my Lord, it's also relevant, I suppose, for this, that insofar as one is looking at derivative claims, causes of action, it may be pertinent to the question of who one joins, who one needs to join. Of course, that is one of the aspects of the Court of Appeal's decision.
Well, what sort of order should we take it in? Do you not think it's best to go to the Limitation Act and see how it fits in, particularly bearing in mind what Lord Walker was saying in Smith?
My Lord, I'm most of the way through my submissions on derivative action. I wonder if I might finish that. If
All right.
Your Lordships please, I'm grateful. I think we've got to 2.7 in the case. We'll be looking at the question of internal management. where there is a claim brought, a derivative claim brought. It may simply be, I'd suggest, an issue of internal management between all those persons interested in the relief claim and all those who've been appointed to represent them as to whether and how any such claim should proceed. It may be necessary to stay proceedings to determine whether or not it's appropriate for the claim to proceed. But that is, we would suggest, no business of the defendant. It's simply a matter of internal management. And we referred in support of that proposition to the case of Harmer and Armstrong at volume 2, authority number 25. This was a claim for specific performance of a contract under seal, where one party, one defendant indeed, entered into it, was alleged to have entered into it as agent and trustee for the plaintiffs and himself. Defendants denied that. Mr. Justice Morm held that he did enter into it as agent, but because he wasn't named as a party, and it was a contract under seal, the principals couldn't enforce it. This was the appeal. On the first point, the appeal was allowed. For present purposes, my lords, I take your lordships to some comments by Lord Justice Romer as to the practice of making a legal owner a party. Perhaps if one starts at page 93. This is dealing with the entitlement of custody trust if the plaintiffs set their own position to enforce contract. At the top of, having referred to various cases, including the Performing Rights Society case at page 92, the top of page 93, Lord Justice Romer says this: in that case, unless I'm much mistaken, the well-accepted practice of this court is that the legal owner of the property in question must be a party to the action, either as plaintiff or defendant. He is the proper person to bring the action. If he does not bring the action, the course which the plaintiff adopts is that of proving the fact and making him a defendant. But the practice of the court, as I understand it, is that the legal owner of the property must be before the court somehow in order that he must be bound. And then he applies that to the present case and then comments at the bottom of page 93. Before going on to consider the other principle, I wish to make one other observation. I entirely agree with what Lord Justice Lawrence has said, that in certain cases it may be extremely inconvenient and indeed inequitable to allow a Cestui trust to enforce his right in this way. The cases to which Lord Justice Lawrence referred are cases in which there was a dispute between the Cestui trust as to whether the right should be enforced or as to the method in which the right should be enforced. Take the case of the residuary legatees of an estate, one of the assets of which consists of a contract by the testator to sell a portion of his real estate. There may be a question of dispute between the residuary legatees as to whether that contract should be enforced against the purchaser and whether it would not be wiser to forfeit the deposit and seek damages. That is the sort of question that might arise, and whether residuary legatees are not at one, or where some of the residuary legatees are not at one with the executor as the course that ought to be pursued, it would be wholly wrong for the residuary legatees who are in favour of specific performance to bring an action claiming that relief, making the executor and the dissenting residuary legatees parties. For the very first question, it would have to be determined in the action as between the residuary legatees themselves, whether in the circumstances it was wiser to ask for specific performance or to forfeit the deposit. In order to form an opinion upon that question, the court might have to consider the opinion of counsel. Of course, all that could not be discussed in the presence of the other parties to the contract. I only say that by way of caution to show that I realise that the principle is not to be extended to every case. Lords, a court of equity always, I've suggested, retains a discretion. I'm not sure whether that's entirely accurate, I don't suppose it matters, but a right whether or not to allow a derivative claim to proceed. And there may be circumstances where it would be inappropriate on inequitable grounds to permit a claimant to make a claim against the defendant. I don't think this is in dispute as an issue. Nurkham and Nurkham was a case where I think a wife in matrimonial proceedings had settled her matrimonial proceedings on the basis that company shares were within them, and then sought to bring a separate derivative claim.
What point are we on here? And again, I'm a bit unclear what precise point we're on here.
This is...
you say is this about whether you should join the trustees, or is it on some other point?
No, this is whether we should join the trustees.
Well, we know the answer there because we've got the rule.
Well, that's... Well, forgive me for my
Unless I suppose say the rule doesn't apply, do you?
This is... the issue here is whether we are obliged to join the trustees as a matter of legal necessity, or whether our joinder of them is purely procedural.
Yes, I mean, you developed this at 212 to 215. I think you're saying you recognise the terms of the rule, but you're saying it's procedural, not substantive, and in effect we shouldn't be deflected from your basic proposition by the fact that the rule requires this to be done.
No, my Lord,
that's my understanding. Thank you.
I'm grateful, my Lord, that is right. My Lord, there is a suggestion made by the respondents, which I've outlined at 2.9, my submission in respect of it, that where you have a derivative action, you require the permission of the court to bring the action. In other words, whether it's a shareholders' derivative action, or whether it's a derivative action as regards a beneficiary, that the court is sanctioning that proceedings, and without that sanction, the proceedings cannot be brought. In my submission, that's not right. This all comes down to matters of internal management and procedure. But rather than go through the authorities on the point, I hope your lordships will be content if I adopt the analysis of the Court of Appeal of New South Wales in a case which is in the authorities bundle, but as it's a case in response, has not been referred to in our case, called Oates against Consolidated Capital Services. And that's in volume 4 of the authorities bundle at authority 46. Lords, the main issue in this case was whether a common law derivative action continued to exist after the passing of statutory provisions in Australia. But on the basis that it did, the court considered the question as to whether permission was necessary to start a derivative action at common law, and in doing so reviewed what appear to be all the relevant authorities. It's the judgment of Mr. Justice of Appeal Campbell, with whom the judges of the court agreed, and the relevant passages start at paragraph 71 and continue to paragraph 107. And his conclusions at paragraph 105.
Page, sorry, paragraph 100.
105, my lord, yes.
quite sure where we're looking. Is it paragraph 107?
105.
105.
If the passage finishes at section finishes at 107,
Yes.
the relevant
Yes, I see. Thank you.
conclusions start at
Yeah.
105.
105 suggests that this standing is a question of cause of action.
My Lord, I appreciate that it suggests that. In my submission, that particular conclusion isn't right. But I can't, and I don't think it would be right for me to bring this authority to your Lordship's attention without pointing out that that is what it said, and it does. So starting at paragraph 105, to summarise, a plaintiff who seeks to bring a derivative action under the general law must allege in the initiating process facts that show that he or she falls within a recognised exception to the prima facie rule, that the proper plaintiff in an action in respect of a wrong alleged to be done to a corporation is the corporation itself. If the initiating process fails to make those allegations, it's liable to be struck out if the defendant chooses to apply to have it struck out. It may be that his Lordship was regarding that as a matter of materiality. If the initiating process makes allegations which, if true, would suffice to enable the plaintiff to enforce a right over the company in which the plaintiff was a shareholder, but the shareholder asserts the allegations are so insubstantial that the matter should not go to trial, the defendant can move to seek a summary dismissal of the claim. Pausing there, that's basically the Prudential and Newman approach in England. If trial of the merits of the action would be long and complicated, a defendant might choose to have a question of the plaintiff's standing to bring a derivative action decided as a preliminary question. But there is no requirement under the general law relating to derivative actions for leave to be obtained before a plaintiff commences such an action. That's a sufficient reason why Mr. Justice Barrett was right in refusing to give the type of relief that Mr. Oates sought to enable him to enforce rights of CCL UK identified in paragraph 39 above. There was lengthy argument about whether if CCL Australia would have been proceedings seeking leave to bring action under the general law against CCL UK, those proceedings for leave would be proceedings on behalf of CCL Australia. Well, that's section 236. In accordance with the judgment which has been decided, that question doesn't arise, and then goes on to state his views on it, which aren't material for these purposes. Lords, insofar as that judgment deals with the question of permission being necessary, I hope your Lordships will not think it's excessively short-cutting for me to submit that Mr. Justice Campbell's analysis of the case is accurate and one that should be followed. I'm more than happy to go through each of the cases.
Please read 98 and 100.
My learned friend has asked me to read paragraphs 98 and 100 to your Lordships, and that I happily do. 98 says this, commenting on Prudential Assurance and Newman. Prudential Assurance and Newman provides no support for the notion that under the general law leave was necessary before a representative action could be commenced. And paragraph 100, even under this new English practice, leave was not required to start a derivative action, only to continue it. And a little tempted as I am to take your Lordships the entirety of the analysis relating to Prudential and Newman in respect of that, I think I will.
If you go back to your 2.9,
Yes.
This case doesn't cite or discuss NERCM, does it?
No, it doesn't.
And so do you say it's to be preferred to NERCM?
I say that NERCM is not authoritative on that particular aspect of the case. In NERCM, Lord Justice Lawton refers to being entitled to proceed as a matter of grace. It is that wording that might give rise to the belief that the entitlement to bring a derivative action is a matter for permission only. However, that's a citation from Gower's company law. Gower's company law relies upon citation for the authority, Tower and the African Tug Company. Tower and the African Tug Company does not say it's a matter of grace. So there is in fact no authority for that proposition. It's a matter of grace insofar as it was relevant in NERCM. because in Nurkham, what was being raised against the claimant was, in essence, an equitable defence, that the claimant had taken the benefit from one piece of litigation and was now trying to chisel out some more by the derivative action. And Lord Justice Lawden took the view, as indeed did Lord Justice Brown Wilkinson, he then was, that this was grossly inequitable. And as it was inequitable, it prevented a doctrine of equity, which the derivative action is, from being relied upon by the claimant. So that is the relevance of the reference to a matter of grace, and that is why in my submission it's not authoritative for the proposition that permission is required before a derivative claim can be
And that was
brought.
only Lord Justice Lawton, the others didn't.
Lord Justice Brown Wilkinson, I don't think he used the same wording.
Well, I don't know.
Yeah, this paragraph 2.9 is where you set the wording out in your case. I don't know whether that helps to make the contrast.
Yes, Lord Justice Brown Wilkinson said that the person interested is entitled to make the claim but may not be permitted to pursue it. It's 377.
Well, we've really reached the final sentence, have we, of 2.9?
Yes. Yeah, my Lord, Lord Justice Brown Wilkinson's, the nub of the judgment, Lord Justice Brown Wilkinson, is at page 378, letter H. So since the bringing of an action requires the exercise of the equitable jurisdiction of the court on the grounds that the interests of justice require it, the court will not allow such an action to be used in an equitable manner so as to produce an injustice. And then reference to Towers. I don't think Sir Dennis Buckley commented on this aspect of the case. No, I don't think so. My Lord, so moving on to 210, we say that as a matter of practice, the legal owner has needed to be made a party to the action for various reasons, all of them good and sensible, avoiding a multiplicity of actions in its various forms, to ensure that payment was made to the correct party. Can I just make one comment about Spokes and Grosvenor, which is cited as authority for that proposition? And it's this. The judgment of Lord Justice Ale Smith appears to be saying that the company is a legally necessary party, so that's a legal obligation judgment. Lord Justice Chish's judgment appears to be saying that you have to join him in order to ensure that the right person gets paid, which is a procedural rationale. So I think it's fair to say that there appears to be a slight difference in emphasis there. And we say that if in the case of the present derivative action, a beneficiary were to succeed, then it would necessarily follow that he would hold funds on trust for the estate. And the only reason for joining the estate in those purposes is that you think the estate is more trustworthy than the person who's suing. That may or may not be right. Thirdly, to enable relief, that is cost, to be obtained against the party to be joined, well, that may or may not be worthwhile. If the party being joined doesn't take any part in the litigation and has no assets, it's unlikely it'll be material. And fourthly, to ensure that all parties derivatively interested in the action were bound to the same result. Again, that's really another version of the multiplicity of actions point. Now, in the Court of Appeal, and I know my learned friend in this House, reliance was placed on
the... A little forward suggests you had to join all the other beneficiaries.
Yes. Yes. If there was a possibility they might have an independent action, that's right. That's what you would do. I expect nowadays court procedure...
Like your clients aren't.
Sorry?
Like your clients aren't.
Yes.
But if the trustee were a party, yes, that would preclude
yes, it should do.
other beneficiaries from having
it should do.
separate
That's right.
rights.
That's Meldrum and Score is simply a case where they did join all the other beneficiaries. I think the reason for that was perhaps not so much as to ensure they were all bound, as to ensure that they were all before the court and could say what they wanted to say, but they were joined. Below and in your Lordship's court, reliance is put, strong reliance, on the terms of the CPR, in particular the rules relating to the joinder of the body corporate. My point on this, although it's extended, is I'm afraid really quite short, and it's this, that if one is obliged to join a party by virtue of a rule of practice, it is, by necessity, a procedural rule. The CPR themselves say that the rules must be interpreted and exercised in accordance with the overriding objective. If for any reason it's not necessary to join somebody and not appropriate to join somebody, then in those circumstances the court won't.
Do the rules expressly provide for that?
Provide.
Do the rules expressly give the court a discretion, even in relation to apparently absolute obligations,
Well,
to relieve a party from doing what the rules say you must do?
that depends on how the rules phrase an obligation to say that he must do it. The Lords...
I remember much discussion about the difference between must and should in the rule.
If the position is that must would work patently justice, I suggest that must would then do justice.
Is there a general overriding power to dispense with or modify?
The only dispensing power is the power that's contained in 1.2, which indicates the rule should be interpreted and construed in accordance with the overriding objective. That's all it says.
You don't say that simply because a matter is regulated by rules, it's a rule of procedure, not a rule of substance, do you?
What I do, I'm afraid, say that. Although rules are rules created under statute and they have the effect of delegated legislation, they are rules of procedure. It's almost as straightforward as saying it's in the title. They are civil procedure. They are not a rule. They are not rules which are required to create the cause of action as a matter of legal obligation. If they were, they wouldn't be necessary. It wouldn't be necessary to put them in the procedure.
But for example, the rules about service out of the jurisdiction, which are rules of procedure, they are substantive rules about the scope of jurisdiction of the English court.
My Lord, that's right.
I think your better point is that if it's subject to a discretion in the court, it may be a rule of procedure only.
Yes. My Lord, the position is that I know that both my learned friend and I have done a little more research in connection with the rules themselves, and this might be a convenient moment to hand up the documentation that we have. They've got yours, haven't they? This is volume 2. My Lord, I know that my learned friend is going to refer to CPR Part 64, which is in, I think, volume 1 of the White Book. I'm going to refer to the Companies Act 2006 and the practice direction under CPR 49, which I'm afraid is in volume 2 of the White Book. I've got 10 copies of my edition. I'll hand that up.
Thank you very much.
And
So this is in the White Book Volume 2, is it?
it is in the White Book Volume 2. I'm afraid your Lordship is getting handed some additional paper. Well, if your Lordships would rather deal with this in the White Book, I'm happy to
No,
leave it like
whichever
this.
you find more convenient. If we've got it all in the photocopy, let's go ahead with the photocopy in the meantime.
My Lord, Mr. Adams has produced some files with dividers on the basis that if we handed up additional documentation, we could slip them in, and perhaps we could deal with that over lunch, if appropriate. I'm grateful. Well, I'll deal with my point first, and then Mr. Dumont. Lord, as far as that is concerned, Companies Act proceedings, the extract sets out the statutory provision for derivative claims under the Companies Act 2006, section 260, to which my Lord Collins has already referred, and also annexes to the back, it's at page 667 of the White Book, the practice direction, and after the usual definitions and application, this practice direction applies proceedings under B, the 2006 Act, except proceedings under Chapter 1 of Part 2 or Part 30 of the Act, which that isn't. One then goes to, over the page, to 9, Section 3, particular applications under the 2006 Act, heading company generally to be made a party to a claim under the 2006 Act. 1, where in a claim under the 2006 Act the company concerned is not the claimant, the company is to be made a defendant to the claim, unless A, any other enactment, the CPR or this or another practice direction makes a different provision, or B, the court orders otherwise. So, insofar as derivative actions are concerned, we say, in fact, that's the position, that the court must make the company a party unless it otherwise orders. It has a general discretion in time.
And is that reflected in the rules?
The rules are set out in volume 1.
19.9a, is it?
Page 477.
Paragraph 3.
Yes. Well, I don't think that this requires the company to be joined.
There's also a practice direction, page 502.
What about 1993?
Yes, that simply says that it mustn't be made a respondent to the permission application.
19.9?
19.93.
Does that not apply?
Well,
Must
yes.
be made a defendant to the claim.
Is that softened by the practice direction?
Yeah.
No.
Doesn't seem to be. You see it repeated actually at page 503, just below this, the side reference 19 CPD 9.
Yes.
And it sets out
Yes.
what the rule says, which repeats the same phrase.
It's 47, it's page 477, isn't it?
Yes, that's the old derivative
Yes,
claim, isn't it?
but it's still, indeed, it's the transitional provisions.
Yeah.
You send a form, is that right? A notice to the company, page 504, 19C.
My Lords, in my submission, the requirement under the rules that a company be joined as a party is not, for the purpose of the division that I indicated at the outset, between legal obligation and procedure, a matter of legal obligation. I do maintain that.
So could you just remind what are the instances where it is a matter of legal obligation, if there are any?
If it is necessary in order to constitute a good cause of action.
Yeah, what, for example?
Well, we don't think there is. We can't think of one where the company would have to be joined as a matter of legal obligation, or the legal owner would have to be. Let me put the point this way. This particular requirement was brought in by amendment to, I think, Order 15 in the early 1990s. Before Order 15 was brought into force, there was no procedural requirement or no requirement in the rules to require the joinder of a company in a derivative action. As a matter of common sense almost, and as a matter of procedure, they always were joined because it would by necessity be an adverse act to the company. If you're alleging fraud on a minority, the company is almost certainly going to disagree with you insofar as it has a separate entity. But it was never required to be joined as a matter of rule. It was always a matter of practice only. So the fact that the rule now exists, in this case in relation to companies, in my submission cannot make it, certainly as far as derivative actions for estates are concerned, or indeed under the common law expressions of a derivative action, a matter of legal obligation. It simply can't.
And do these new rules apply in this case?
These rules don't, because these relate to companies.
Well, yeah, but apart from that, I mean, would they in terms of time? I mean, none of the rules apply to this precise situation, do they? Either the pre-existing ones or the present ones?
No, had this been a corporate derivative action brought when it was, then the new rules would have applied. There's no, that is plain.
What is the date we're looking at? The transitional provisions say that from 1st October 2007, new rules came into force. I think your application was dated August 2006. Does one date it back to then?
Yeah, hold on a second. My Lord, I'd noted, I think, your Lordship's comment that the former rules are set out at page 503.
Yes.
And those were in force before the 1st of October 2007.
And they contain the same provisions.
Same provision, so I wasn't able to take a point on the difference
Right.
at the time. And the original rules are set out in Order 15, Rule 12A, and that's Volume 1, Tab 5.
Sorry, Order 15?
Rule 12A, my Lord, it's page 257.
So before September the 1st, 1994, there were no rules, were there?
I think not, my Lord. Well, I'm just looking...
So there were no rules before September the 1st, 1994, so presumably some other principle must have applied then, or maybe the same principle, but not derived from the rules. Yes. And these rules only apply to companies. There are no rules that apply to this present situation.
Well, I know my learned friend is going to refer your Lordship to the practice direction relating to estates, trusts and charities, and suggest that that applies. I think I'll leave him to do that
Right.
if I may. But I've been looking back through this rule to see whether...
Is it helpful to break off now? It's after 1 o'clock, and it might be better to come back to this at 2 o'clock. How are you getting on for time? We've, I think, used 2.5 of your 3.5 hours.
My Lord, I'm taking rather longer than I thought I would do. That's undoubtedly right. I think I've gone through the majority of my submissions on the point on appeal. As your Lordships know, there are, in effect, cross appeals in respect to the two aspects of the case. I rather hoped I wouldn't be very long at all with those.
Well, I think our concern would be that there's enough time for Mr. Dumont to make his submissions, and then you'd have a chance to reply to what he says. So I think you should have an eye to those requirements when you consider how you address us this afternoon. But we'll rise now and look forward to seeing you at 2 o'clock.